Did the magazine ever get sued, actually? For something relating to coverage, not some,
We got sued once by Roy Cohn.
Oh, really? Okay.
Yeah, and he dropped the case. Okay. I mean, in my life, I've been sued by Roy Cohn and George Wallace.
Oh, okay.
The only people ever sued me. But George Wallace was something I wrote in New York Magazine with the same results. We won. But we'd get threatened all the time. But, and these guys, they just have to type it out. They don't have to hire anyone.
Yeah, so, exactly. That's the problem with writing about lawyers.
The odd thing was we always got libel insurance. I always wanted to short the stock of any insurance company that would insure a magazine like ours, because as you know, the issue with libel litigation isn't whether you win, it's what it costs you to win.
Legal costs, exactly. Floyd Abrams isn't cheap.
Yeah. But we got sued a couple of times, but not anything serious.
Well, how did you make the migration then? This is sort of relevant for me, and this is of interest to me for the website that I run that covers the law above the law. How did you make the migration from being this scandalous publication when you showed up at the conference giving copies out to a publication that is now very well respected and everyone talks to it and everyone gives you financial numbers that you used to have to fight for? Well, not exactly. I mean, but yeah, it's exactly because you sold it. But
we never thought of ourselves as scandalous. I thought of myself writing for the American Lawyer the way I thought of myself a month ago writing for the New Yorker.
Well, why did the law firms find it scandalous?
Because people, there was this culture in our country, and it's a good culture, which is that lawyers should not be tagged with their clients. And therefore, if, there's an investigation, a communist witch hunt, and some lawyer wants to stand up and defend a client, you don't assume the lawyer's a communist.
Sure. Okay.
Or if you want to stand up and defend someone accused of being a terrorist, you don't assume the lawyer is a terrorist. And that's a good thing. But somehow over the years that translated into that kind of anonymity, i.e. I'm not associated with my client, to total anonymity, which means I'm just nobody. I'm Sullivan and Cromwell, and you don't know anything about me. I don't tell you anything. And I might be an institution with 600 lawyers and 1,000 employees and $1 billion in revenue making all these decisions, but I'm just nowhere. And that's just, journalists should love the idea that people try to be anonymous that way. That's just one good story after another.
Now, well, that's interesting. That's a positive.
And the harder the story, the better it was for us. I mean, the AmLaw 100 started as the AmLaw 50, and I was sitting around one night having a couple of drinks on a Saturday night trying to think of a good story we could do. And it dawned on me, this was I think 1985 or something, that we already knew the numbers probably of 20 firms because we'd done profiles of the firms with the managing partner or something. So why don't we just do this Fortune 500 like ranking? And I came in the next day, and I remember Jill Abramson, who's now the managing editor of the Times, was one of the reporters, and Jim Stewart, and Ellen Pollack, and Steve Adler, who were at Business Week, and a bunch of people. I called it, and Jim Cramer. I said, all right, we're going to do this. And I said, we're going to do the AmLaw 500. And they quickly got me down to 100. And then we ended up compromising on 50 for the first year. The first year it was the AmLaw 50, then it became the 75. And we just, the hard part was, the Fortune 500 is public companies. I mean, that's easy. A monkey could do that. But this was getting these numbers out of, and we would triangulate guesses, and we do all these things. And it was a lot of work, but it was fun. And anyone who did that could do any business story. But the theory of it was that basically in journalism, if 10 people know something, you can usually find it out. If 10 people, and usually more than 10 people, i.e. the number of partners in a firm, know something, and half of them are pissed off about it because they know that someone's making more than them who they don't think should be making more than them. Well, then you can really find out about it.
Well, let me ask you, and this is sort of related to the challenges that journalism currently faces, something like the AmLaw 100. We would love to do something like that on Above the Law. That's very resource intensive. It takes a whole team of reporters. It takes pouring through public records. It takes going through deals and who represents this company in this transaction or this litigation. How is that kind of journalism possible in this economic environment?
About 10 years ago, publishers en masse decided to commit suicide by giving away everything for free. And it's just utterly stupid. Your business model is not going to work long term, and it shouldn't, because you're not putting it to a market test of whether anybody thinks it's worth anything. Now, I
don't know if that's completely true. You need to have enough traffic to monetize the advertising, and if you have
you're
no
never
traffic,
going to monetize the advertising enough on a long-term basis, because the one thing that's true about advertising on the internet, it's an unlimited supply that is multiplying exponentially.
But I have a question, though, about niche journalism.
There's no barrier to entry for someone. If I decided tomorrow that I wanted to compete with you, I could hire 6 guys and take away half your advertising.
But is that true, though, in the sense that we have lots of other competitors? They haven't really acquired much traction yet. But I think, in a way, the market does monetize.
If they did good stuff, they'd acquire the traction.
But isn't the same true in the print world as well?
Yeah, no. But the problem with depending only on advertising is that the market doesn't respond in a direct way to what kind of resources you put behind the reporting. In other words, I used to have once a year, one of my publishers, whether it was at Legal Times or the American Lawyer, would come to me and say, I have this great idea. Delta Airlines will only charge us $15,000 to give away the American Lawyer for free at the Delta shuttle at LaGuardia. And we can raise our circulation by 10,000 or 15,000, whatever the number of people is who are going to pick it up for free.
Sure.
And therefore we can raise our ad rates. And I'd say, that's a really great idea. What about the people who are paying $500 a year for the American Lawyer? You're going to walk past the shuttle and see that we're handing it out. What do you think happens then? And so the publishers are always balancing ad revenue and circulation revenue. When you decide that there's no circulation revenue, you have no place to go when the economy goes bad, for example, and advertising starts to go down just by virtue of the economy, and you have no barriers to entry. If someone decides, I can write that stuff too. Now, you guys have done a great job. I mean, it is just a scandal that the American Lawyer's websites aren't successful the way, you shouldn't exist if the American Lawyer was doing its job.
Well, thank you.
But that, now, the question is what you do to make that a long-term business proposition. I have a daughter who is a second-year law student at our alma mater.
Oh, excellent.
And so she's going through the process this fall of fielding job offers, as happens with Yale law students who actually want to practice law, and she does. So she's on your site all the time.
Oh, glad to hear.
So she's interviewing at a firm, and
is this your daughter Emily?
No.
Oh,
no,
sorry.
That's a different daughter.
Oh, okay. She's in me. Oh, okay.
So she says to me the other night, she's interviewing a firm, and she starts spouting off stuff about this firm. I said, well, I'm not sure that's right. I actually think that. And she said, no. I said, well, why do you know? She said, well, I just checked it out on Above the Law today, and they say that. I said, well, okay. And then I looked at it. It seemed right to me. I saw what she was looking at. Now, you can't tell me that she wouldn't pay you $2 a month to do that.
Well, we're not actually, I wouldn't say we've ruled out that model. I know that Journalism Online, the new venture you're working on, has signed over 1,000 letters of intent. Maybe we should be 1,001.
No, in fact, I've been after your putative owner about that.
Oh, okay, interesting.
But now what you would say is, well, gee, if it's such a hurdle for her to do that, well, if she could just pay with a click, which is what we're doing.
Yeah, the iTunes
it'll make
model.
it very easy. But the fact is, you have something valuable in the sense that she knows that you're a source of reliable information. And if you only monetize that with advertisers, two things happen at the same time. One is you're only loyal to your advertisers because your advertisers call the shots. The second thing is you're vulnerable to someone who comes along and says, well, we're just going to write the same thing and we'll do a lot of advertising. We'll make a marketing deal with LexisNexis and have ads pop up when people do who knows what. But you're vulnerable and you're not really living off of the value you create.